everyone, this is Danya Shakfeh from Shakfeh Law. Today we're going to talk about contracts. Now, there's a lot of myths about contracts, a lot of misunderstandings about contracts, and I actually write a lot about contracts on my website and my blog. So feel free to just hop onto my website at shakfehlaw.com and you can browse through the topics and you'll see that I do write a lot about contracts. Now, contracts are actually pretty basic at their core. They really just have three elements. One, contract is an offer, acceptance, and consideration. So the offer is, I'm offering you to buy my house, and then the acceptance is, yes, I will buy your house, and then the consideration in this particular transaction would be the amount of money that the buyer is going to pay the seller. Now, consideration does not always have to be money. It could be, someone will do something for someone else. For example, I'll wash your car if you mow my lawn. That's a contract. And so contracts can be oral and they can be written. However, it's better to have a written contract because when you have an oral contract, you have a lot of dispute as to what the terms are, whether there was a contract. So it's not that you can't have an oral contract, but it just becomes a matter of how you prove that there was a contract. However, there are some types of contracts that do need to be in writing in order for them to be enforceable. There are three categories. The first is when you have a sale of goods for more than $500, when the transaction involves real estate, or when the contract is for more than a year. Another common misconception about contracts is that if this concept of standard or boilerplate terms. The danger about these terms, I see that a lot of people don't take standard or boilerplate terms as seriously. So oftentimes when someone asks me to sign a contract, and they don't usually know I'm a lawyer, but someone like a contractor who comes to my house and does some work, they'll often say, oh, well, these terms are just standard. You can just sign it, but they're just standard terms. And I don't know what those terms are, but hey, they're just standard. And the implication is almost as if you have to sign it because everybody signs these types of terms, or that maybe it's not as enforceable, that it's almost like meaningless. And so that's dangerous because one, these terms are enforceable, and two, they are actually negotiable. Whether the parties choose to negotiate is something else, but just because everybody else agrees to terms doesn't mean that you are required to. So don't fall into this trap. If someone tells you, oh, just, sign it as standard, feel free to ask questions. Say, well, like specifically what is standard and why should I sign it? And can you explain what it means so I know what I'm getting into? Because yes, it is enforceable. So for these reasons, as you can see, it's very important to understand what you are signing and understand the ramifications of what you are signing. So if you have a question about a contract that you are being asked to sign, or you want a contract drafted so that you can have someone else sign it and you want to actually enforce your own rights, I really advise that you do have a lawyer review it. And so if you're in that situation, you can give our office a call at 630-517-5529. And there's also the contact form at the bottom in the description